colleagues. I am Dr. Sonia S. Kanetkar and I am back with my medical legal tip number 7 and 8. I hope they are useful to you, so please continue your support. So, today we are going to talk about complications. Sometimes we feel the patient doesn't know, they will just try to put legal hassles on you whenever some complications occur, whenever death occurs. But we have to be aware that whenever there is a complication where which is known in this world, which everybody knows, there are evidence based medicine. So in that case, you don't have to worry. A person who files a complaint with the police regarding saying alleging that in the treatment there was some negligence because the wife died. There was a case like that, and the complication of the surgery happened. This was in a case where the mitral valve was replaced, the surgery was done, and after the replacement, the patient, the wife died because of the sepsis and the complications of the surgery. But these were known complications. These are known to the world that such complications do happen, and there can be risk of death. So in such a case, the council found that the doctor was not guilty of negligence in the treatment given as a known complication. So he cannot be charged for medical negligence. This was order number DMC DCF 14. You can put this in the Google search and read about this case. It is very interesting. This is just to give you a tip that please do not be afraid if complications happen in your case. They are not here because of your negligence. Then medical legal tip number 8, which is about medical records. We are always worried about medical records. Suppose sometimes we make a mistake and then we correct it. So I'm just going to tell you how to do that correction. It is called spoliation of medical records. That means if there has been some change, so you have written something by chance and you want to change it, then you how to do it in a proper way so that it will not be considered as a tampering of the records. So, medical records are the basis for medical practice claims, and if your records are properly done, they're properly corrections and all have been done, then nobody can disregard them. So, spoliation of medical record means negligent, reckless, and intentional destruction of evidence. So, the DGHS guidelines, it should be followed to prevent spoliation in a case. So that means if you are having a case, a litigation against you, and suppose you have done some corrections, not deliberately, but before the litigation, and but they have not been done properly, then they will be considered as spoliation, and unnecessarily you will have trouble. So here I want to give this tip to the doctors, all my colleagues here, how to do the correction properly in genuine mistakes made in the records. So, points to prevent spoliation is that when you are correcting an error, strike out the incorrect statement with a single line and place your initial and date next to it, your signature and date next to it. Then make the correct entry in the record below it. Attempting to obliterate the erroneous entry by applying a whitener or scratching through the entry in such a way that a person cannot determine what was originally written raises the suspicion of someone looking for negligent or inappropriate care, right? So then you will be charged. Now, entries in a medical record should be made on every line. Suppose you skip one line, then it leaves a room for the people to doubt that you have left the room for some corrections or you wanted to make some, tampering of the record. So please do not try to leave any lines. In medical legal cases, the record should be in the custody of the doctor who examines the patient and finalizes the report. No one else should have access to it because somebody can actually tamper with it and cause problems for you. Okay, so correcting of personal identification of data of the patient like name, father, husband name, age, sex, address should only be done on the basis of affidavit by notary or first class magistrate. This means that suppose you are under litigation but you found that there has been some correction of name data, some false name has been given, then only if you have notary's this thing, or first class magistrate's information, then only you should do it properly, so that it is not considered as a spoliation. In case a correction is done, for example, date, any spelling, and dose at the time of treatment, the treating physician must sign near the corrected area and put the date and time when the correction was done. So that's all for today. Thank you very much for listening to me, and I hope it is useful for all my friends, and I hope you live a peaceful life.